XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. Despite recent trial setbacks, U.S. Securities and Exchange Commission, SEC, Chair Gary Gensler maintains that most crypto assets are securities and need SEC monitoring. According to Gensler, the cryptocurrency sector's crisis stems from widespread violation with current securities rules, the allusion to the 1920s economic collapse, before to the formation of securities laws, demonstrates Gensler's opinion in the urgent necessity for rigorous regulation in today's quickly expanding crypto industry. This analogy, as well as his strong convictions on the matter, are expected to be reaffirmed as he prepares to testify before the Senate Committee on Banking, Housing, and Urban Affairs on September 12. Gensler has repeatedly emphasized the Howey test, a legal measure used to determine whether an asset is deemed a security. He emphasizes that since the bulk of crypto tokens meet this condition, the onus is on crypto intermediaries to follow securities legislation. This viewpoint, however, has not been widely embraced. This became clear when the SEC's charges of federal securities law breaches were dropped in their legal battles with Ripple and Grayscale. The hearing will also offer insight on two of the SEC's most recent proposals. One investigates crypto asset custody mechanisms, while the other seeks to amend the definition of exchange to legally include cryptocurrency platforms. The crypto community is watching the Senate committee hearing with bated breath, hoping for clarification on Gensler's developing views, particularly on industry heavyweights like Bitcoin and Ethereum. While Gensler has previously classified most assets as securities, with the exception of Bitcoin, he has been somewhat unclear regarding Ethereum's precise categorization, a point that has caused arguments between the SEC and the Commodity Futures Trading Commission. Lang told CNBC that her business intends to defend the SEC's case to the very end. The Ripple CEO said that Judge Annalisa Torres' decision bolstered the company's resolve and gave clarity by saying that XRP is not a security, saying that security. According to her, the verdict has also allowed the corporation to extend its operations not just in the United States, but even more globally. In July of this year, Judge Annalisa Torres issued a summary decision in favor of the business, ruling that XRP was not a security and that the company's programmatic sales and other payouts did not constitute investment contracts. Given a result, it is reasonable that Lang and Ripple will be ready to see the case through, given the odds seem to have shifted in their favor as a result of the court's decision. Although the SEC plans to appeal this ruling, analysts estimate that if the court permits the interlocutory appeal, the commission will certainly lose. Ripple may also be aiming to leverage a possible win against the SEC to reestablish investor trust in the cryptocurrency business. This is particularly true given that the business's David Schwartz, recently said that the SEC's action caused the company to lose major agreements. Ripple and the SEC are hell-bent on seeing this litigation through, implying that there is no end in sight to the legal struggle, which is now approaching 3 years and is likely to continue on longer. Furthermore, if the court grants the SEC's request for an interlocutory appeal, Ripple and the SEC will have to square off in court again before the jury trial starts. Following the landmark XRP ruling, the Securities and Exchange Commission, SEC, has increased its efforts to seek a mid-case appeal against Ripple. This legal dispute, which began in December 2020, is about whether Ripple violated securities laws when it made XRP available to retail investors through various cryptocurrency exchanges. While the SEC has vehemently argued that XRP is a security subject to federal securities laws, Ripple has always argued otherwise. Ripple recently filed a document arguing that the SEC had not presented a compelling argument to justify an appeal. However, the SEC's response, filed on Friday, September 8, emphasized the significance of the case, stating that the issues raised by the recent ruling presented precisely the kinds of knotty legal problems that prompted Congress to provide for interlocutory review cases of the same nature. While interlocutory appeal should be the exception, not the rule, this is the unusual case where the defendants themselves say that the issues have industry-wide significance and are of special consequence, and thus is precisely the type of case as to which the Second Circuit has invited. Interlocutory appeal, the SEC argued. The SEC's decision to appeal stems from Judge Annalisa Torres' ruling in the United States District Court for the Southern District of New York on July 13 that, While Ripple had indeed violated federal securities law in its sale of XRP to institutional investors, the company had no wrongdoing in relation to retail investors. Meanwhile, in response to the latest SEC filing, Ripple's chief legal officer, Stuart Alderoty, stated, "Another SEC filing, another hypocritical pivot. After years of its chairman claiming that the rules are clear and must be followed, the SEC now claims that an appeal is urgently needed to resolve these knotty legal problems." Alderoty's statement emphasizes Ripple's belief that the SEC's position has been inconsistent, emphasizing the need for transparency and clarity in the regulatory approach to the crypto sector. Nonetheless, as the legal battle between Ripple and the SEC continues, the outcome of this appeal request now rests with Judge Annalisa Torres. If she grants the SEC's motion, the case will be sent to the Second Circuit Court of Appeals, where the entire crypto community will be watching to see how this historic legal battle plays out. According to Chach, XRP could reach a valuation of $500.50 by 2024. While this figure appears astronomical in light of its current market position, it highlights the potential that XRP may hold in the eyes of its supporters. The model also speculated that if XRP achieves such a significant rise, it could potentially surpass Bitcoin and Ethereum in terms of market capitalization. Such a result would be unprecedented and could reshape the entire crypto landscape. However, it is critical to note that this is purely speculative and should not be construed as financial advice. Regulatory actions, technological advancements, and market sentiment, among other things, could all have an impact on the future of XRP. Having said that, the crypto market has always been full of surprises. While XRP faces numerous challenges, including ongoing legal battles and widespread adoption, its supporters remain optimistic. Ripple's president, Monica Long, has proclaimed the company's resolve to defend the litigation to the end. Ripple's intention to challenge the SEC's regulatory stance is consistent with those of other cryptocurrency businesses, such as Binance and Coinbase, which are seeking regulatory clarity and rules for the crypto sector. Despite the difficulties, Ripple is determined to prove the SEC's claimed dishonesty and grow its worldwide commercial potential. Ripple President Monica Long said in an interview with CNBC that the business would continue its legal battle with the SEC. "We intend to fight the case all the way through," Long asserted emphatically. Ripple Labs and the SEC have been fighting in court for over 3 years. In a partial triumph for Ripple, Judge Torres determined that programmatic XRP sales are not securities but are instead investment contracts. Notably, the court stressed that XRP is not a security in and of itself. Despite the partial victory, the SEC has filed an interlocutory appeal, alleging that the Howey test shows that XRP should be classed as a security. Federal justices have also chastised the SEC for its capricious and hypocritical handling of the case. Monica Long noted that the judgment gave some certainty for the cryptocurrency market and allowed Ripple to extend its operations abroad. As it prepares for the trial in 2024, the corporation hopes to expose what it sees as the SEC's hypocrisy. "We also got clarity in that lawsuit," Long said, and the judge's decision in that case said unequivocally that XRP is not a security in and of itself, which allows us to really extend our business, not only in the United States, but much more abroad. In the face of market uncertainty, XRP plummeted and fell below the critical support level of 50 cents. According to CoinMarketCap, the digital currency has dropped roughly 4s in the last week and is now trading at 4,808 cents. Monica Long, Ripple's president, remains defiant in the face of the SEC action, vowing to battle to the last end. Despite XRP's pricing problems and market instability, Ripple is forging forward with worldwide development ambitions. As the court struggle continues and the crypto sector seeks regulatory clarification, Ripple remains undaunted, aiming to highlight the SEC's apparent inconsistencies. Despite the challenges ahead, Ripple is committed to expanding its cross-border solutions and investigating new use cases for XRP in the changing ecosystem of digital assets.